admission of extrinsic evidence for contradiction impeachment is restricted to non-collateral matters, so that evidence that impeaches by contradiction and is not collateral can be both substantively admissible as well as admissible for its impeachment value. And that is coming from Baylor, B-E-H-L-E-R versus Hanlon, H-A-N-L-O-N, 199 F-R-D 553. And then the parenthetical is surveying numerous commentaries. Judge, with respect to Mr. Sledge, the reason that I began my statements to the court about what it is that he said, and will then go into what his lawyer said. When I asked his lawyer about plea negotiations on the heels of Mr. Sledge, not just saying he was told he could get up and tell his truth, but on cross-examination, he was asked repeatedly through the use of allowable leading questions. These weren't your words. You didn't write it. You didn't understand it. You didn't know what you were signing. You felt like you could come in here and tell your truth. You signed it regardless. I'm not directly quoting, but essentially, even though it wasn't true, you signed it. And things of that nature were elicited during cross. You signed it because you wanted to get out to go see your sick mom, things like that. You were in Fulton County Blues. That's the only reason you signed it. These aren't your words. These are only the state's words. So all of those questions were intended to attack the credibility of the veracity of the statement that Mr. Sledge made on December 28, 2022, when he signed the plea agreement. And Mr. Sledge acquiesced to all of those attacks, essentially asserting through his sort of obfuscations and running back and pulling back my truth. I don't understand. I don't recall. I don't remember saying that. That isn't true. And his pointing out at the state's request the factual acknowledgments.
Interior Define, custom sofas made for you. Why settle on a sofa that's made for everyone else? Choose from hundreds of fabrics and sizes to make your sofa uniquely and only.
Himself and the cross-examining attorney to, in front of the jury, completely question or to undermine the credibility of the statement that he made and his own credibility at the time that he made the statement. So as the court has already instructed the jury that the inconsistent statements of a witness are also substantive evidence that may be considered against other persons on trial. Can the court hear me okay?
Yeah.
All right. So as the court has already instructed the jury that it can now consider that statement as substantive evidence, what we've seen is an attempt by the defense to destroy the jury's faith in the credibility or veracity of that statement made by Mr. Sledge on December 28, 2022. So when questions were posed to his attorney regarding Mr. Sledge's understanding of those acknowledgments and sentencing agreements, on the one hand, after he made clear that though he's a friend of both sides, he's a defense attorney through and through, Mr. Wright, though he did clear it up, he seemed to, his answers on cross-examination, there were some things that were not true. There were some things we didn't agree to. He was kind of vague with it, and it took belaboring point by point for him to even acknowledge hey, number 3, number 8. These are the only 2 anybody took issue with. So at this point, Your Honor, I believe that the iterations that were presented to Mr. Wright and to his client per his words are important because it is further evidence that corroborates Mr. Sledge's understanding of and his understanding of the final plea agreement that is 1AS and 444Y, and his ability to effectively engage in and have an active hand in that final document that he signed on December 28, 2022. It points not only, it demonstrates not only the inconsistencies of Mr. Sledge's testimony, but his outright perjury regarding his purported lack of ability to have any say in what that final document asserted that he signed. It is illustrative of the fact that he actually did have the ability to tell the state what he felt wasn't true and what parts he wanted changed. And I think that our position is that it is relevant in showing or allowing the jury to judge the credibility of statements Mr. Sledge has made on the stand versus the credibility of the statement that he made on December 28, 2022. The statute that I cited earlier, it substantiates our position that the representations that Mr. Sledge made under oath on December 28, 2022 were part of a long and detailed negotiation and refinement that Mr. Sledge himself took part in. I think at this point, 24-1-104 might become relevant. That's the one I brought up earlier that didn't have any bearing on what we were talking about. But in as much as 24-1-104 speaks to the code section not limiting the right of a party to introduce before the jury evidence relevant to weight or credibility, we believe that this particular evidence allows the jury, it is pertinent evidence that they should be allowed to see, to understand fully what was put before Mr. Sledge, what he did dispute, what he did not dispute, and what so that they can compare it with what he finally agreed to and make a better determination about the truth of the statements he made on December 28, 2022. I think that the argument that some of the statements, the allegations made by the state, those are things that one way or another may be asserted in any event. For instance, they caught nut down bad is a statement that we know is going to come out either through the person that said it, the person that relayed to law enforcement that they said it, or in his statement to police if he lies on the stand. These aren't matters that are so prejudicial that they should be kept from the jury. These iterations, if you will, the defense wanted to have us reference part of them, but pointedly objected when I attempted to have Mr. Sledge show or point out differences between a previous iteration and the final version. That previous iteration was not circled there. It's one that I have because I did not tender it as a marked exhibit. They actually objected to my calling it a previous iteration. And I think in attempting to keep from the jury, not just the previous iteration, but the number of them and the changes that were made and requested, and the changes that were not requested, as is reflected in 460Y, we're keeping rather from the jury very relevant, pertinent evidence that in no way substantially prejudices either defendant through its admission. So I believe that an instruction that these are assertions made by the state, essentially questions that they ask the witness, then defendant, are these true? I initial them if they aren't, tell me what changes need to be made, and that they are not to consider as true from this witness or as take as statements by this witness anything that doesn't appear on state's 444Y, and that they should look at state's exhibit 460Y as substantive evidence of the defendant through his representative of what he was calling true and not true at the time that the state presented him the iteration that came just before it. So it allows them to put in context Mr. Sledge's factual acknowledgments and sentencing understandings that he signed.
I'm gonna get copies made of all of these.
Yes, Your Honor.
All right, so. Just one. Oh, batteries, thank you. All right, I've got some batteries. If
Oh,
you
did they
think
go in
that
here?
might help with, I'll just put them up here.
Double
Yeah. It seems like your mic is out and I need batteries. I don't know whether they take double A or triple A.
Double A over here.
All right, got a few of each. I'm just gonna set those right there. All right, so I think that, you know, there's the 444Y one, which is the signed plea acknowledgement. That's sort of a separate type than all of the rest of these correspondences back and forth. And are you at this point saying, just so I understand, that like as to 460Y, you don't even intend to redact it at all?
No.
All right, help me understand what you're saying.
As to 460Y, I wanted to redact everything except the one email that Mr. Wright sent. I want to take out everything else before. I even think I included twice in that 460Y, the same email. So I would like to redact out all of that except the email from Mr. Wright to me on December 27th at 8:43 or thereabout at night, wherein he is making statements for his client. So they are statements of his client that number one is okay, number two is okay. And I say that under, I would call it an adoptive admission, but he is
Well,
an
it's
agent.
an agent,
Right.
yeah.
So he is stating, his client is stating, number one is okay. And in order to know what number one is, the jury needs to see what number one was that I sent to them, which would be the exhibit directly preceding, which I believe is 452. If I'm wrong, I'll make that correction. But the jury should see 452, wherein Mr. Sledge says, that's okay. They should see whatever he wrote about 450, about number two.
Let me ask you something. I mean, is he really a party opponent anymore?
He
He
was.
But is he now? Because admitting it in this trial now, is that an admission by a party opponent?
Oh, you mean in terms of the,
You're saying, you know, this is a statement by Mr. Sledge's agent, which it is,
Oh.
but would that get admitted under the admissions by a party opponent exception to hearsay?
I wasn't admitting it under
Okay,
that.
so-
I was just saying that they are statements of Mr. Sledge.
Okay, all right, but under what exception do they come in?
They are Mr. Sledge's statements. He is a witness who was on the stand, who was subject to cross-examination. So in as much as they are inconsistent and contradictory to the testimony that he gave.
Okay. So I can see 444Y coming in as a prior inconsistent statement because he definitely testified inconsistently once he was on the stand to what he said in that document, which admitted as factually true all of those things that he initialed.
Right.
So that's a separate item, and I'll hear argument on let's deal with that one. 444Y.
Is it my turn?
Okay, so don't talk about the rest of them until we get past.
Not yet, because I think this is kind of separate than the rest of them.
Okay.
Because it's a different type of document. So do you want to say anything else about that? You saying it's a prior inconsistent statement and it's impeaches him by contradiction.
Yes, and it corroborates the state's position and.
Well, I know why you want it.
Corroborates the state's position is
That-
not a hearsay exception.
Right, I understand that. Yeah, so why is that not come in
Okay.
as a prior inconsistent
Your
statement?
Honor, first, I just have to address one thing.
Okay.
And I'm sorry, I'm not trying to be a whiner. This is exhausting because every time we are on the same page and Your Honor seems to direct us, things somehow get relitigated. We were up at the bench and we all looked at 444 or we,
No, 444 is a different one, but yes, 451 through 6 and 460.
are we talking about the emails right now? Or are we talking?
No, what I wanted to talk about right now is the actual final plea
Okay,
acknowledgement.
so I'll address that.
Okay,
We all talked about this and we determined what would be admissible as prior inconsistent statements. And the state was allowed to read and confront, and he acknowledged that he signed. So he never said he didn't sign those things. He explained it. But those factual acknowledgments on the 1AS, which I think is 444Y, were read into the record and fully litigated. And we not only heard from Mr. Sledge, but then we heard from Mr. Sledge's attorney for a day. And the whole process of how everything happened was covered ad nauseum. I think the jury gets it. And there's nothing that I would understand to be gained by admitting the paper copy of what was testified to and discussed over a week with, this gentleman and his lawyer on the stand, however many days it was, that hasn't already been covered. Additionally, Your Honor, of course, my stance would be, if it were to be admitted, it would not go back to the jury because it would be continuing witness. It would be, signed statements, written statements, and the idea that somehow, well, that deals more with the prior versions, but
yeah, let's
you
not
know,
get to that.
yeah, I won't get to that yet, but we've discussed this, and now we're back to arguing about it again.
I don't actually know that we discussed 444Y 1AS.
Well, the state sought to admit it at one point, is my recollection, and you instructed the state to ask about the ones he was denying, and they confronted him, and they said, "This is what you're denying." Factual acknowledgement. I'm using an example. 3, and then it was read, and then it was discussed, and then we went from one to the other to the other. The state was certainly not rushed in their examination of Mr. Sledge. So all this has been covered. There's no need to admit the document into evidence at this time. And it's cumulative, but also it should never go back to the jury to begin with. So I don't even know what purpose it would serve at this point.
Well, we can deal with that later, what goes and what doesn't go and what's subject to a continuing witness objection. But it's definitely a prior inconsistent statement. Y'all were given an opportunity to cross him on it. He was given an opportunity to explain it. It can come in as extrinsic evidence.
Well,
That-
okay.
It's pretty clear law, I think.
Well, the other thing is, I don't know if he denied, the other thing is he didn't deny adopting it. He said, and he gave an explanation.
I
but-
know.
Right, but I don't believe that lays the foundation for a prior inconsistent statement. Him saying, "Oh, I did sign this, and this is why I signed it,"
Okay.
and then, so
Well, the statements on the document say every bit of this is true, and I acknowledge every bit of this. And he testified inconsistently to that with regard to the majority of it.
he did, but he never said at the time he didn't acknowledge it to be true.
I think he did. Okay, so to me, I don't know if the entirety of it or just the parts that he denies are admissible, but does it really matter?
It
If,
does.
1, 2, and 14 through 15 come in?
I'd have to really look at it, and this is, the state has not given us a proposed redaction, but
Well, I don't, do you propose to redact that at all?
No, and just as a
Well-
point of clarification, on the first day of direct examination, he specifically said that one was not true. He said that on the second day, he came back and said yes, but the first day he said no.
it's interesting that Ms. Love says that, because when she actually was examining him, she misspoke and said that he adopted number 1. So now she's saying he denied it. Yes, I believe that if we're going to admit them, if the state's not willing to redact it, then it should not come in.
All right, so
What is it that they're proposing that we redact, Your Honor?
It's-
the
I'm-
parts that he didn't testify inconsistently with.
So I believe that the document as a whole serves to rebut it's a contradiction. The document as a whole is a contradiction, impeachment by contradiction. It serves the other, the 3 things that he said he admitted, 10, 11, and 12. I'm sorry, 5, 10, 11, 12, 14, and 15. Provide context to the types of admissions that he was willing to make. It provides context.
All right, well, didn't they watch a video
Not
of
with-
you reading out
Not
just the parts that he said were inconsistent?
yes, just the parts that he said were inconsistent. And I believe that the document as a whole is evidence, powerful evidence of what the document contains, of the statements that he makes in the documents. I think it's evidence. The fact that he signed, the fact that the document exists, the fact that they can see what it is that he was looking at, and compare it with what it is he is saying on the stand, allows them to further assess his credibility. It corroborates what they saw. It corroborates his understanding of what it is that he was signing.
All right, if we're talking about is it an exception that permits his admission, it being corroborative doesn't get you over that line. So. Yes, sir. Yeah. Now, it may be that what you mean to say is that the entirety of the document needs to come in because that's the only way they can understand it. Is that what you're saying?
Yes, I'm sorry for not doing it as well as the court did. When I say context, yes, it is the only way that the jury can fully understand the document and what was before Mr. Sledge at the time that he signed it.
The state's stance is that the jurors can't possibly understand one factual acknowledgement about a video, for instance, without being provided another factual acknowledgement about gas stations on Cleveland Avenue. That acknowledgement about gas stations on Cleveland Avenue just sheds light on this acknowledgement about the video that allows the jurors to understand that. That's ridiculous.
You had him admit on the stand the factual assertions that he still agreed with, right?
I had him not read from the document.
Did the jury in any way hear the factual acknowledgements that he still acknowledged?
I believe that the
If you
answer
know
is
the
in
answer.
some form of fashion.
If your dog has food sensitivities, their food might have ingredients that don't agree with you or your dog.
And you said it, and I think the Honorable Attorney Sharp just said it. My memory, and according to my notes, the entire, from the swearing in of Mr. Sledge, then it skipped. And then the entirety of his acknowledgments, whether he admitted it or did not admit it, was read over my objection on a video audio from Crime and Law, or Law and Crime. And now we're doing it again. That's in evidence. So I'm objecting to it. It's already there. And the state at one time told you that they needed that evidence in because it shows demeanor and he had an opportunity to sit next to his lawyer, and that there was no one else in the courtroom, and Mr. Williams and I and the others weren't there to intimidate him, or whatever their word was. This is just cumulative. He's been impeached. He's been thoroughly impeached. So I'm objecting to 444 at all.
And at the appropriate time, I'd like to respond.
The answer to your question is yes. It has been acknowledged.
So your recollection is that on the video, every factual acknowledgement was read.
Yes, that is, if I'm wrong, please correct me. I'm not trying to be wrong.
He's
That's according to my notes. There was nothing redacted. It went right from the acknowledgements, whether he agreed or disagreed. It was read by Miss Love.
All right, Ms. Love, I know you sent us an email at some point that said, here's what I intend to play,
Respectfully, Mr. Steele is incorrect.
right?
We did.
Okay, so hang on. And was sent Friday, September 6th at 7:45 a.m. And then, yeah, I think that's the right date.
And what
Then
we,
maybe again to me at 9:54 a.m.
right. Would the court like that we put it on the screen or just reference the portions that we were taking out?
No. Oh, yeah, no, you didn't play the ones that he said were true. You only played the ones that he said were false.
Right. I know. Yes, Your Honor.
Okay. Okay, so,
And when the court feels it appropriate, I just had a couple of more words to say in response to Mr. Shart's response about 444 and impeachment by contradiction and the amount of time spent on it.
all right, I'm not concerned with the amount of time spent on it.
Okay. then not that, but-
So the ones that are prior inconsistent statements are the ones that he said were false. So if you're arguing that the entirety of the document should come in, what's your basis? Your basis for that is it's the only way for the state to